Welcome everyone. Thank you for joining today's session. My name is Xiaoling Li, and I have been working in the field of intellectual property for 12 years. My practice focuses on trademark prosecution, disputes, and enforcement. Over the years, I have supported clients in protecting and defending their trademark in a wide range of industries. I've had the privilege of providing IP legal services to more than 800 clients across over 40 countries and regions, including Fortune Global 500 companies. These experiences have allowed me to develop a practical, business-oriented approach to solving trademark issues and supporting brand strategies. I'm very happy to share my insights with you, and I hope you find this session helpful. In this session, we'll talk about non-use cancellation. Although formally, non-use cancellation is designed to remove registrations that have been used for 3 consecutive years. In this session, we'll talk about non-use cancellation. Although formally, non-use cancellation is designed to remove registrations that have not been used for 3 consecutive years, it has become a key technical tool. It is also used to challenge bad faith registrations, particularly those filed by trademark squatters. It is also a useful tool in trademark negotiations. In short, non-use cancellation is an important tool for managing trademark portfolios in China. This session focuses on recent trends in non-use cancellation filings in China and the corresponding filing strategies that applicants must consider. We will review updates to cancellation filing requirements, current examination tendencies, and we will also outline practical steps for ensuring compliance and effectiveness of cancellation filings. Here is today's structure. We will begin with an introduction explaining why this topic matters. Next, we will review the key updates to the examination requirements of CNIPA, Trademark Office in China. Then, we will analyze recent examination trends led by the updated requirements. Finally, we'll discuss practical next steps for applicants to navigate these changes effectively. First, let's see why the updates to non-use cancellation filings are important. Over the past few years, CNIPA has tightened its requirements for non-use cancellation filings. In the past, it was possible to file the non-use cancellation action relatively easily, with minimal documentation. But today, easy filings are no longer accepted. It is crucial to understand CNIPA's current evidence requirements, how they affect applicants, and which strategies are now necessary to maintain compliance in our cancellation filings. This is the purpose of this session. In the past, the threshold for filing a non-use cancellation in China was extremely low. Applicants could submit minimal documentation to request for cancellation. Generic allegations of non-use were often accepted. Any individual or entity could file with simple statement about non-use of a mark which registered for over 3 years. This environment was one of the reasons for the dramatic increase in non-use cancellation filings. But this surge isn't just about clearing unused marks. It's also driven by practical needs in trademark prosecution. In China, if a trademark is rejected due to conflict with prior similar marks, a letter of consent is not currently accepted as sufficient evidence to overcome the rejection in most cases. As a result, applicants facing such rejections have limited options available to them. One of the remaining and most accessible options is non-use cancellation, which has a relatively low filing threshold. Given this accessibility, applicants often rely on non-use cancellation as a practical option to remove blocking prior rights. So, the combination of procedural ease and strategic necessity have contributed to the rapid surge in non-use cancellation filings over the past 3 years. You can see that the number of cancellation filings were 150,000 in 2022, but it increased to 230,000 in 2024. Additionally, cancellation actions are abused for malicious purposes. In response, CNIPA designated the crackdown on bad faith non-use cancellation as one of its major priorities for 2025. This movement is a direct driver of the strict standards we observe today. Beginning in 2023 and continuing into 2025, CNIPA has tightened its requirements, which are applicants must now demonstrate the likelihood of non-use. This means that concrete preliminary evidence is required at the time of filing. Applications without such evidence may be rejected or viewed as bad faith actions. This marks a significant departure from the previous practice. Although the examination requirements have changed, the underlying laws remain the same. China adopts a registration-based system, and non-use cancellation exists to ensure that trademark rights reflect actual commercial use. It purges unused marks, deters malicious registrations, and protects fair competition. These fundamental principles have not changed, but the interpretation and application have. So, what are the key updates to the CNIPA's requirements on cancellation filing? According to the trademark law, any entity or individual may file a non-use cancellation. The purpose of the mechanism is to ensure that trademarks function properly as indicators of commercial origin and to prevent waste of trademark resources. The burden of proof is shared between the applicant of the cancellation action and the trademark registrant. The applicant must demonstrate non-use or likelihood of non-use. The registrant, in turn, must provide evidence of actual use during the relevant 3-year period. On May the 26th, 2025, CNIPA updated its examination requirements on its website. These updates provide detailed guidance on procedure. The updates clarified the required documentation for filing non-use cancellation and provides a subdivision of the preliminary search evidence. Significant changes were made to the requirements for evidential materials. Under the updated requirements, applicants must state the relevant circumstances regarding the alleged non-use in the grounds for cancellation. It is also required that applicants must submit preliminary search evidence. The submitted evidence must show that the challenged trademark has not been used for at least 3 consecutive years without valid reasons. The requirements specifically mention online search results, market research reports, and similar materials. According to the updated requirements, preliminary evidence may include corporate information about the registrant, such as business scope, current registration, and business status, existence of the corporate, as well as past trademark filings under the corporate name. The preliminary evidence also includes market search findings regarding the trademark, such as searches conducted on online search engines, the trademark owner's official website, WeChat accounts, or search on e-commerce platforms, search results of market survey, or on-site inspections of the trademark owner's business premises. The preliminary evidence also includes market search findings regarding the trademark, such as searches conducted on online search engines, the trademark owner's official website, WeChat accounts, or search on e-commerce platforms, search results of market survey, or on-site inspections of the trademark owner's business premises. This evidence must support the applicant's claim of non-use of the trademark. The updated requirements also highlight the applicant's commitment, that is, before submitting an application, applicants and their representatives must carefully read the mandatory honesty commitment. By filing the application, they are deemed to have accepted the contents of the commitment. This commitment reinforces the obligation to act in good faith, to conduct genuine preliminary search, and to ensure that all information submitted is truthful and complete. This commitment includes several key responsibilities. The applicant, agent, and agency must adhere to principles of good faith. They must confirm that, after search, no use of the trademark has been found. All reported matters and submitted materials must be true and complete. They acknowledge that submitting false materials or concealing important facts constitutes dishonest behavior. If the commitment is untrue or not fulfilled, it may result in credit penalties or other adverse consequences. So, with these strengthened honesty obligations in place, CNIPA has begun to incorporate them directly into its examination practice. In other words, the updated requirements are now reflected in the examination trends. This brings us to the next section, where we look at how these new standards appear in the actual examination of non-use cancellation actions. This slide outlines the typical formality examination flow for non-use cancellation filings. After submission of application with grounds and evidence, the application enters formality examination. After the formality examination, CNIPA may accept the filing if the submitted grounds and evidence are sufficient. Otherwise, CNIPA may issue a notice on correction to require the applicant to supplement additional evidence of non-use. If the supplemented evidence is acceptable, CNIPA will issue acceptance of filing. If the response to the notice on correction is still not acceptable, CNIPA issues a non-acceptance decision. In some extreme cases, the CNIPA may directly issue a non-acceptance. In the formality examination, examiners have frequently issued notices on correction, requiring the registrant to submit evidence of use. They request applicants to supplement non-use evidence or correct procedural deficiencies. Mostly, these correction notices are based on the updates of the requirements. Common requirements include information on the registrant's business scope and operational status to see whether the trademark registrant is good standing or not. Searches on comprehensive platforms such as Baidu or on industry-specific websites to check whether there are clues for trademark use. Required keywords for search are like registrant name, trademark, and name of designated goods. When an official website of the registrant is found, further explanations are required to clarify the challenged trademark is not actually properly used in the official website. If repeated cancellation is found, applicant is required to request the CNIPA to suspend the latter action until the former case is concluded. Correction notices have become a common part of the process. As substantiated and good faith filings are required, examiners now adopt a more conservative, evidence-driven approach. In some extreme cases, if the non-use claims are obviously inconsistent with preliminary search result, in other words, the allegation clearly do not match the submitted evidence, CNIPA may directly issue non-acceptance. However, such direct non-acceptance is not a common case. After the requirements were updated, CNIPA introduced cases of bad faith cancellation filings. Bad faith in cancellation filings can be seen in several patterns. The first pattern of bad faith relates to excessive volumes of filings. For example, an individual filed 57 non-use cancellation actions. These cancellations are filed against marks owned by multiple different registrants. Such behavior suggests profit-seeking motives rather than protection of legitimate rights. applicants should be careful about filing high volumes of cancellation actions without proper searches. The second pattern concerns cases where applicants file cancellations even though the trademark is clearly in use. A typical example is the trademark Red Alert for online game services and computer software, which is well known to the public. CNIPA is of the opinion that the applicant filed a non-use cancellation action against this trademark, which has established recognition on its designated goods and services, in spite of its actual use or constructive knowledge of the actual use. Filing against such marks indicates disregard for the facts and may be treated as bad faith. Applicants should be careful about filing non-use cancellation against the marks that are actually used and have significant market recognition. A third pattern involves repeatedly filing cancellation actions against the same mark, which greatly increases the registrant's costs. For example, the trademark Xiangbalao, which means countryman, faced 38 cancellation actions. Among them, 31 cancellations are from applicants associated with the same law firm. This creates unnecessary administrative burden and is likely to be treated as abusive. Applicants should be cautious in repeatedly filing cancellation actions against the same mark. The fourth pattern concerns conflicts of interest. Some agencies have filed non-use cancellations against the trademarks that they themselves previously registered for clients. This constitutes a violation of the Trademark Agency Supervision Regulations, which prohibit representing parties with conflicting interests. Applicants should avoid filing non-use cancellation against the mark through an attorney who handled the trademark registration of the same mark. The fifth pattern involves intentionally filing false non-use actions and abandoning them during the formality stage. For example, some applicants abandon false non-use cancellations by not responding to correction notices or not paying official fees. Such actions are deemed as misuse of the administrative system and violate the principle of good faith. As a result of current trends, the burden on applicants has increased substantially because of following reasons. Higher volume and quality are required for preliminary evidence of non-use. Applicants may need to cooperate with experienced agencies to ensure compliance of the filings. Above facts may also result in increasing workload and relevant costs. Applicants also need to pay attention to the impacts on related cases, such as refusal review cases that dependent on the outcomes of the non-use cancellations. In summary, applicants must ensure that their cancellation actions are based on genuine non-use concerns and comply fully with the good faith principle. Here are advices on next steps for the applicants in non-use cancellation filings. Under current trends, as an overall strategy, applicants should adopt a good faith strategy supported by proper search and evidence preparation. This includes, first, applicants need to revise the internal strategy to evaluate whether to file cancellation based on search results. Second, applicants need to revise a strategy from simple filing to conducting pre-filing search. Third, it is advised that handling each cancellation case by case, rather than applying a one-size-fits-all approach. Regarding how to prepare non-use evidence, before filing, applicants should thoroughly conduct searches on following: restaurant's operational status. For example, dissolution of the restaurant company can be one of the strong evidence to prove potential of non-use. Revocation of licenses and abnormal operation status may be considered as signs of possible non-use. We may check whether the designated goods match the products in the official website, and whether applied for mark and the used marks match. We can also check number and scope of registrations owned We can also check number and scope of registrations registrant's own trademark filings to see whether the registrant is likely to have been holding trademark registrations. Here are some examples of channels for evidence collection. We can use Baidu.com, Bing, or Sogo.com as search engines. For example, we can use Tmall Taobao, JD.com to search whether the trademark was commercially used in e-commerce platforms. Available SMS searches include Weibo, Rednote, WeChat, and TikTok, etc. We can also use industry-specific platforms such as National Medical Products Administration website for search used on pharmaceuticals. If the trademark is registered on restaurant services, we may search websites like Meituan, Dianping, and so forth. Applicants also must verify whether there are prior cancellations. If the mark was maintained in a recent previous cancellation action, CNIPA may cite the earlier decision and make similar decision in the latter case. If there is a pending cancellation, the latter case may receive a notice on correction. The CNIPA may require the applicant to request for suspension of the latter case in order to wait for the outcome of the former cancellation. Even so, filing the latter cancellation may be necessary, as prior decisions may still be overturned at review or litigation stage. In summary, sufficient search and evidence-driven filing strategies are essential. Of course, check repeated cancellation is also necessary. Applicants must maintain good faith and avoid any behavior that may be interpreted as abusive or dishonest. As we've discussed, non-use cancellation practice has changed significantly, but with the right preparation, non-use cancellation remains a very powerful tool to clear obstacles, protect legitimate business interests, and secure stronger trademark portfolios. Therefore, it is recommended to maintain close coordination with experienced local agents to adapt quickly to procedural changes. All these steps will help ensure compliance with the updated requirements and enhance the effectiveness of non-use cancellation filings. This concludes my presentation. Thank you for joining this session. If you have any questions or would like to discuss specific cases or strategies, please contact us. Thank you.